Hi everyone, here's today's real consumer question from a real consumer. Wendy sent us a query about a very common complaint, a contractor who isn't doing what he was hired to do. She writes, Dale, I hired a contractor to renovate my 1920s era bungalow. Things were going well at first, but then he submitted a change order adding nearly 10% more to the project. He's also taking too long to perform his work, and it's very shoddy. His crews are very haphazard as well, so we decided to just stop the bleeding and send him on his way after we had already paid him $29,000. However, he's now sent us a breach of contract notice, and I'm scared that I have to pay him another $25,000. What should I do? Wendy, you're in familiar and unfortunate territory. We hear your circumstances a lot here at TrustDALE, even when the homeowner seems to have hired the best companies to work on their homes. With all the businesses, I always understand that mistakes can happen, but how a company responds and remediates those issues is what's important. But it sounds like you've exhausted your attempts at having your contractor repair those problems. Our attorney friend Lisa Rose reminds us of the good news and bad news for you. In your state of Georgia, the legislature passed a law called the Right to Repair Act, and other states likely have similar statutes that are designed to help you. The bad news is that it's very timely and specific in what you must legally do in order to get what you deserve. The intent of the Right to Repair Act is to protect homeowners while also reducing the number of lawsuits that bog down the courts, or even lowering the amount of arbitration cases, as it appears to require in your contract. In any dispute situation, remember to clearly document each of your disagreements with photographs and written reports from the others you had inspect your issues. The Georgia Department of Law's Consumer Protection Division provides a summary of Georgia's Right to Repair Act. It's a good resource as it lays out detailed steps that a homeowner must take over a 3-month period before a homeowner can even file a lawsuit, such as requiring the homeowner to provide the contractor with a written notice of their complaints. Remember, the goal of this act is to reduce litigation by requiring communication and hopefully compromises between the two parties. Your situation involves a lot of money and grief, so I would seek a contract attorney to steer you through this one. For those of you who may be considering a construction project, I strongly recommend you get a thoroughly itemized agreement with firm completion dates. You'll be glad you did, and we wish you the best, and thanks for writing us.